topics and opinions expressed in the following show are solely those of the host and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon, Houston. Welcome to another Ask the Experts, where we bring you the top experts in the field of health, legal, financial, and home improvement. Our expert today, who's with us twice every month, I actually spent a little bit more time with her introducing her because she's one of my favorites. She actually founded her firm, her law firm, back in 2007. She's celebrating her 15th year anniversary. And let me tell you something, when you can be an estate planning attorney and you can brag about being in practice for 15 years, you've really done something well. You're taking care of your clients. She specializes in estate planning, related areas such as probate, guardianship, elder law, special needs. You've got to have a heart when you practice estate planning, and Julia definitely has a heart. Let me bring her on, attorney Julia.
Hi, Steve. Thank you so much for your kind introduction.
Well, it's well worth it. I know you're not feeling well today, and we're going to trudge through this for the next 25 minutes. We'll just pray for healing for you.
Right.
It's always so good to have you on, Julia, because when it comes to estate planning, it is so important. And some people probably don't appreciate you till later on, but there's so much that you can do to help an individual, help a family for the future. Why don't you tell everybody a little bit about yourself and your firm?
Thank you. Well, we just love proactively helping people avoid issues. And so we're planning their estate, whether, through wills or trust, planning for disability, but we're trying to avoid issues through estate planning. But when we can't avoid them, then we will, intervene and help you along with guardianship or certain elder law crisis planning or probate. So, but our goal is to get out before that, think through the issues, and help you avoid those issues.
Well, Julie, first of all, you must have this long checklist of things to do that people should never try to do this themselves because they are going to leave out so many things. But our last show, we were discussing documents that our listeners need to think about as part of a comprehensive estate plan. Do you find it's good estate plan is more than just getting these documents in place?
I do. I think most people just think of the documents, but I think there's another step that we should take, and that would be to really communicate that plan with our family, our loved ones, our trustees or executors, whoever. Oftentimes we'll have a family meeting or a trustee meeting to explain the plan so they know what it is and kind of have an overview, who to talk to, that there's, we've already established that relationship so they don't feel uncomfortable coming into the office. in a disability situation or of a loved one or a passing of a loved one. And then we can talk to them about, just some things they may need to think about at critical times, and they can ask questions. Actually, this last Saturday, we had a preferred client maintenance seminar. We do seminars for our trust clients that, just talking about what does your successor trustee do? And I think those are really important things. And part of that is just also knowing where the documents are and, where to find these things so that we minimize the aggravation and the responsibility. Well, the responsibilities are there, but just, we can make it so much easier on them if they know where things are, all the documents are in place. And we've already had some of those hard discussions with family.
I love this idea about having a meeting with the family members. How far down should you go on the family tree as to who should be at this meeting?
I would generally say your beneficiaries after your spouse should be there at least. If you want to have more, that's fine. But usually that's our children, and getting them on the same page, because really one of the biggest risks to our estate plan, having issues with it, is our family, and our beneficiaries who we've named. And that really can be a problem when they're creating all these issues that we never intended for them to have. Sometimes just an explanation about why, especially if we're not doing equal distributions. We may be doing an unequal distribution because one child has received more during their lifetime, or they have, additional needs than another one has. They may have taken care of the parent, or we anticipate they would be the one taking care of the parent. So just being able to address those beforehand and just, and then I think, sometimes it's the little things, who gets what of the stuff, who gets my china and who gets my silverware. I mean, it's just ridiculous.
How about the pets?
Yeah, the pets too, just talking about what would happen. And so I think if they know the plan, and they may not be happy with it, but they've gotten used to it before we've had to implement it, is going to avoid a lot of issues in the future, because they know this is what their parent wanted. It wasn't a mistake, that something happened this way. So I think that's important, to get that taken care of.
What are some of the biggest risks to our estate plan that you can see?
Yeah, other than our family, I've seen, well, let's talk about some of that within the family. I have seen where one parent or one child is living off the parent, and has already kind of drained a lot of the resources before the plan is even implemented. And now the other children feel like, well, that was really unfair. I mean, they've lived off their parent all their life, given hundreds of $1,000s or whatever, and we're now splitting it equally. It just doesn't feel right to them, that's really what their parent would want. And oftentimes that happens when the parent's in a vulnerable position. They're sick, or they're getting along that phase of incapacity, and really they're vulnerable to more undue influence by this child who is willing to manipulate them and take their money from them. And so if we can do some things to protect it beforehand, that's going to be very important.
Julia, do you find yourself being the bad guy sometimes?
Sometimes, yeah. Yes. So I try to kind of get ahead of that. So like if I know that there's been a diagnosis in the family, like there's a dementia, I will really encourage my clients at that point to resign, or include the co-trustee right now, so that we're not having that period of vulnerability. Or maybe we switch from a revocable trust or a will, and we go ahead and go to irrevocable planning for Medicaid purposes or other purposes, just for protection purposes, so that we have a trustee that's managing that. Sometimes that means we might need to put in a corporate trustee, because we don't have a child that we can depend on to make those decisions, or another loved one. And that's so much better than having family issues directed at your children or other loved ones that are stepping in and doing the right thing. Sometimes there's so much bad blood already that the best thing we can do
Yes.
is not make it worse by naming any of them in that role. And so a lot of times I see parents want to put all of their children on there then as co-trustees, because then they'll have to work it out. That does not work out. That, I can almost guarantee you 99% of the time, they're just going to go at it, and now it's going to be worse. So it's worth the cost of a corporate trustee where they can blame the corporate trustee or someone else. And then there's always a recovery. So if we have a bad actor and they're draining account, well, if you have a corporate trustee, if they were bad, you can recover against them because they're insured and they're bonded and they're licensed. But if we have an individual doing that, really most people, you can't recover from them because most of their assets you can't go after if they're that kind of person anyway, so they probably have no non-exempt assets.
I like the way you talk about how to avoid some of these situations. Are there other things that you can do? That's why I think your position is so important, Julia, because you've got I wouldn't say your crystal ball, because you've been through so many different examples of things that happen that a person like myself wouldn't even think about.
Right. Yeah, I think, going ahead and getting ahead of that with the resignation, getting trust planning in place. If we don't have trust planning, getting it in place or modifying it, getting that corporate trustee. We could also do a disability panel. Sometimes people want that to make that decision without having to rely on the doctors, because sometimes the doctors are reluctant to state that you're disabled and unable to handle your finances or make your medical decisions. And especially with finances, that puts us at a vulnerable place too, because they don't want to take away your rights. So they wait until you're so far along that Alzheimer's, dementia, or that disease that's progressing, where you've already had so much happen, or you've done crazy things by giving away money to people who are calling our predators or caregivers, that you've already kind of decimated your estate. And so if we can have maybe a disability panel of people that you trust, then we can go ahead and get that in place sooner in a trust situation. And then one that you may not have thought about before, but I had one client do this and I thought it was just such a great idea. He tested his beneficiaries. So like his children, he would give them lifetime gifts. And he would say, he just watch and see how they used them. Did they do them well? Do they use them well? Do they save? Do they invest? Or do they just spend it all? And then if he saw that they weren't handling things well, then he would take them out of roles of authority. Or he would make sure that their trust had more restrictions on them. And I thought that was just really a great way to, start thinking about, okay, down the line, I'm not going to be here. I'm not going to know what's going to happen. So let's start testing them and just see how they would handle that.
We just got a text from a listener, really enjoying the show. What do you do if your parent keeps taking you in and out of the will?
And so,
that's one of the difficult parts about your job.
It is. So if the parents have capacity, there's really nothing we can do, because they have the right to make those changes unless we've already created an irrevocable trust situation. But a revocable trust, like a living trust or a will, is changeable as long as they have capacity. And the level of capacity for a will is less than some of the others. And that's where we do get a lot of undue influence in other things and going in and out of will. So sometimes it's because they're in that state where they're paranoid, because of a dementia diagnosis. Some people go through that phase of time where they're paranoid. And so they're constantly changing who their beneficiaries are. It's going to probably be a fight where that dementia was at a point where they no longer had capacity to make that decision anymore. And I hate to tell you that, because that's not a fun answer to this.
Yes.
I'd like to have more certainty, of course, but unfortunately, they're free to do that as long as they have enough capacity, to make a decision regarding who gets what. And kind of the level of that is they need to know, at least generally, what their assets are, and who would be their natural people that would be their beneficiaries, or their heirs. Do they know their children? Do they know who they are? If it's not children, do they know, parents or siblings or whoever? Are they able to, have at least that capacity? And do they know kind of the level, or, their assets? Maybe not to the detail, but they kind of know they have that retirement account and that savings and checking and a house or whatever. So as you can see, it's still a really high level of capacity on that, and so that's where we kind of come into those situations where you do kind of go in and out of that when they have undue influence. And sometimes that influence can be through, a spouse or a friend or a caregiver, and that's where it's really difficult.
We just had somebody write us, can you tell me the difference between a will and a trust?
Between a will and a trust? Yes.
Yes.
So a will is, I'm going to call it your legacy plan. We're going to say who gets what. We can say how they get it. It could be in trust or outright. And we can do some tax planning. We can do some asset protection planning if we're doing some planning inside the will. So we can do things inside a will, but it's really who gets what and how they get it. Now, a living trust is who gets what and how they get it. So that's a legacy plan too. It's in place of that will generally. And then it's additionally a disability plan. So it's a living trust in that it's activated right now with your assets that you're putting into it. And so if there was a disability situation, you have pre-named someone who can step in your shoes as trustee and be able to handle paying your bills and taking care of things in your disability as well. So that's the nice part about it, is that we're not only avoiding a probate and we're saying where everything goes, but we're also avoiding a guardianship because we have people in place that can handle things in your disability. So a will, even though it's a legacy plan, it goes through the court. A living trust, if it's done right, it will not be going through a court. And so we can avoid court in probate and in disability with a living trust. Whereas with a will, it's only activated upon death. A court has to say that that it's a valid will. You can't just take it to a bank like you could a trust. You have to have a court validate it and say, yes, this is a valid will. We're going to admit it to probate. And then they have to qualify your executor and give them authority. So they swear them in, they give them the authority, and they issue what's called letters testamentary, which is the authority from the court to handle things. So that's kind of the major differences between the two. But both of them are still very flexible. You can change them. You can revoke them. You can do a whole new estate plan.
Here's another one. Barbara, thank you for the show. She wants to know if you do seminars to the public.
Yes, I do. Actually, I just got through with one. I did one for the public library, and probably had about 50 people. We were talking about some of these issues and some elder law issues today. So actually, I just got back a few minutes before this started. And just a great group with lots of questions. I love answering questions and educating. That's just my heart. And so I'm happy to do any kinds of events or talks for different groups that you may have. So thank you.
I know why you're so good at that. I just out of curiosity, what are a couple of the most asked questions at your seminars?
Usually one is, well, I have a will, so that means I don't go to probate, right? And no, that doesn't mean that.
Right.
It means you have a will. And now we have to have a court say, yes, that will is valid. And that's the probate process. And then we need, just because you've named someone as executor, doesn't mean they have authority. The court has to give them authority. So that's the biggest misconception, I think. And I get that question a lot. The other is, can I just do a deed and beneficiary designations and be okay? Well, yeah, you can piecemeal things together, and if you get it all right, it might work. But you can't do, if any piece falls through, then we're going through court. And if you don't have a will, now we're going through a much more expensive heirship proceeding to determine who the heirs are. It's not necessarily going who you want it to go to. So we have a beneficiary designation, but that person dies, and now we don't have anyone in place and you haven't updated. That's the situation where we go through a probate and maybe an heirship if we don't have a will. If we have certain kinds of deeds, there are some ways we can transfer assets to our loved ones upon death. And sometimes the people want to piecemeal it that way too, if they have real estate. There are some issues with that, like the fairly new transfer on death deeds. I'm hesitant to use them because they do transfer to people and the laws allow that. The problem is creditors can still come for up to 2 years. And if they can show fraud up to 4 years from when they say that. And so if your loved ones that are receiving it want to sell the home, now most title companies won't sell the home. So there's other ways we can do it, and we can work with you to try to avoid probate in other ways. But we have to be really careful about that sometimes it's not worth saving a little bit on the front end because we might be risking thousands of dollars on the other end that we didn't need to risk on doing that.
I have a lot of questions, but we're getting a lot of text. Here's one, and it's going to give us a good end to give everybody your phone number. It says, what is your phone number? Your show has made me nervous. It looks like my father is getting dementia, and I want to get his books in order.
Yes.
You hear a lot about dementia now.
You do. It's very prevalent. Actually, both my mother and my mother-in-law were diagnosed with it in the last year. Oh. And so we're dealing with it on both sides, and it is so hard. And even though this is the area I work in, there's just some things that laws don't help with. I mean, we do everything we can, but there's just dynamics that are just difficult. And so I'm so sorry. So my number is 281-277-3326. And my website is juliadeanlaw.com. So JuliaDeanLaw.com. So if you just want to send a request for a consultation, then my office will reach out to you as well. So thank you for asking. And, you know, I know it can make you nervous, but it's better to be knowing that there may be some issues and that we can look at it, because there are some things we can do now to pre-plan to help with that. And, you know, it depends on the stage they're in. If they're at the beginning of dementias, they still may have enough capacity that we could get a person in place to make the right kind of decisions and even get trust into place for them. Even today, I'm signing something where we signed a power of attorney that allowed this daughter to go ahead and do a trust, a Medicaid asset protection trust for her, because she knew it was kind of beyond what she could handle at this point in her incapacity. But because she trusted her daughter, we could get a power of attorney in place that allowed her daughter to do that and to handle that. So, you know, there are things that we can do. And maybe we need needs-based government assistance like Medicaid. Well, let's do some pre-planning for that as well, because we may be looking at many, many years of needing care. And right now it may be okay at home with some care, but that's going to progress. You know, right now, like with my mom, we're looking at progressing from 40 hours a week to pretty much round the clock care. And so, you know, it's very, very difficult, but things will change over time, and this is going to be dynamic. So having the power for someone to handle those decisions and to still provide, the financial and medical and other support that they need is really critical right now.
To pre-plan your legacy and protection in the event of disability, seriously, I'd like you to call Attorney Julia Dean. Again, her number is 281-277-3326, or you can go to her website. She's got a wonderful website, Julia Dean, DEAN law.com. And sincerely, I endorse Attorney Dean. We've been together for about almost 3 years, and she's just the best. Julia, get better, first of all.
Oh, thank you. I
And
appreciate that.
we will keep your mom and mother-in-law in our prayers for healing.
Thank you. We appreciate
Thank
that.
you so much. Julia's with us twice a month, and she will be back again. Thank you, Julia, so much.
You're welcome. You have a wonderful day.
You too. God bless.
Thank you.
She is just a wonderful, wonderful attorney. Again, her number is 281-277-3326, Attorney Julia Dean. And that's it for us today. We will be back again with you next week with more Ask the Experts. We've got some great experts lined up next week, right before Thanksgiving. And everybody have a safe week. We'll see you soon. Take care.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.